Good day to everyone in South Africa, the US, and wherever you are watching from. We are delighted you've made the time to join the Legal Resources Center and our distinguished speakers in this important conversation about democracy and race in the US and South Africa. My name is Thandi Ole, and I am a trustee and chairman of the Legal Resources Center. I am an attorney and an alumni of the LRC. I joined the LRC in the mid-1980s during the last kicking of a dying horse's days of the apartheid regime. The Bram Fischer Lecture was established in 1995 by the LRC to honor Advocate Bram Fischer, QC. The very first person to give the lecture was President Nelson Mandela, who described Bram as one of the staunchest friends of South Africa's freedom struggle. When he delivered that first lecture, Mandela said, and he expressed his desire that the conversation the LRC was starting to honor Bram should continue for as long as South Africans yearn for freedom in a non-racial, democratic South Africa. The events of the past 18 months have reinforced that the struggle for racial justice is far from over, in South Africa, in the US, and globally. For that reason, the LRC decided to change the format so we could include people from other parts of the world who share those values and ideals with South Africans. I am delighted that Nicolette Naylor, the International Program Director for Gender, Racial and Ethnic Justice at the Ford Foundation, and Anthony Romero, the Executive Director of the American Civil Liberties Union, the ACLU, will be the first participants in this new format. Before Nicolette and Anthony start this important conversation, I want to talk a little bit about Bram for those who are watching and who might not know who he is. Bram was part of the legal teams that defended Nelson Mandela in both the treason trial and the Rivonia trial between 1956 and 1964. In fact, he led the defense team for the Rivonia trial that avoided the death penalty for President Mandela and his co-accused. Bram was later put on trial himself for furthering the aims of communism, then a crime in South Africa, and sentenced to life imprisonment. Bram came from a very prominent Afrikaner family. His grandfather was a prime minister of the Orange Free State, and his father the judge president of the Orange Free State High Court. So his support as a white Afrikaner for the freedom struggle was deeply unusual. As many have noted, Bram challenged his own people because he felt that what they were doing was morally wrong. In doing so, he showed profound courage and made sacrifices that few matched at the time, and I may dare say even now. Bram was arrested in September 1964, released on bail, and permitted to go to London to argue a case before the Privy Court in Britain. Despite pressure from family and friends to stay in the UK, he returned to South Africa to stand trial. That's how strong his convictions were. The day after proceedings against him commenced, Bram failed to appear in court, and his counsel read out from a letter explaining why he was not in court. I'm going to read a section of that letter because it is relevant today. I quote, "If by my fight I can encourage even some people to think about, to understand, and to abandon the policy they now so blindly follow, I shall not regret any punishment I may incur." What is needed for white South Africans to shake themselves out of their complacency? A complacency intensified by the present economic boom built upon racial discrimination. Unless this whole intolerable system is changed radically and rapidly, disaster may follow. I close quotes. These words are still relevant today, and they resonate far beyond South Africa. For as long as one group of people is able to benefit from the privilege bestowed on them by their race at the expense of others, the society President Mandela and Bram fought for, one based on equality, freedom, and dignity for all people, remains elusive. Bram was underground for a year before he was finally arrested in November 1965. He was found guilty of furthering the aims of communism and conspiracy to throw the government and sentenced to life imprisonment in March 1966. He died of cancer at his brother's home in April 1975 after an international campaign obtained his release on compassionate grounds 2 weeks before his death. In a final act of malice, the prisons department of the apartheid government insisted that his ashes be returned to them after his funeral, and they have never been located and returned to his family. Now, ladies and gentlemen, it is my pleasure to hand over to our moderator, Sherylle, who will introduce Nicolette and Anthony. Thank you.
Good day to everyone who is joining us for this important conversation. I'm Sherylle Dass, and I'm the Regional Director of the Legal Resources Center based in Cape Town. And we're joining us for a new format of the Bram Fischer Lecture. I'd like to introduce Anthony Romero. He's the Executive Director of the ACLU, and Nicolette, who is the International Program Director, Gender, Racial, and Ethnic Justice of the Ford Foundation. Welcome, Nicolette and Anthony.
Thank you. Hello. Thank you for the welcome.
Hi, thank you.
I want to just say first how thrilled I am to be part of this lecture and how I'm a lifelong admirer and supporter of the LRC. And I'm just thrilled to be here with you and thrilled to cheer you on as you do the important work of today, building on the important work that the LRC has done for decades. And to be here with Nicolette and with you is really a privilege.
So today we're going to be talking about race and democracy in the United States and South Africa. But I'm going to start by asking Nicolette about the global picture. In February this year, the UN General Secretary Guterres described white supremacy as one of the biggest challenges facing the world. Do you agree?
I think this is a yes, but a qualified yes. I think it was important for the UN Secretary General to be calling out white supremacy as a transnational threat and an internal security threat. And I like the fact that he called out that racism perpetuates inequality and the call for global solidarity. That was also important. But I think calling it this evil thing is a missed opportunity. It's not the boogeyman out there. It's structural and systemic, and it's embedded in the very structures of our institutions, including the UN. So I think the Secretary General's statement is important, but he could have gone further to recognize that it's not out there in some bad apple countries. It's in the texture of our global human rights architecture and our global institutions and the way the UN itself is engaging with the global South or with Africa. I think we need to make those kinds of connections. I'm much more happy with the statement he made last week, where he said that vaccines and travel bans, he called it travel apartheid, calling out that that wasn't about safety or about COVID protocol, but it was anti-African and anti-Black. And I think that's important, and calling it apartheid was also important. But I think this whole, the human rights infrastructure is implicated in racism. And so I think that that's a missed opportunity. The other point I think is that we mustn't overemphasize the importance of what the Secretary General has said. It's not that important. We must be careful of attaching weight to statements and rhetoric without real action. And so I think that statement amounts to very little without action or accountability. So what steps is the UN going to take internally and externally to address white supremacy? I'd be much more interested in some of that, because we've seen lots of statements over the last year. And the final point I'll make on this is another missed opportunity is when speaking about anti-Blackness and white supremacy, we must make the point that it's global and gendered. And locating white supremacy alongside patriarchy and misogyny is important. What Moya Bailey refers to as misogynoir, the place where racism and sexism meet, and the specific hatred of Black women, and the silencing and untold stories of Black women. And so when we're talking about race, bringing that intersectional analysis, you have the Secretary General, when it's 16 days of activism, he talks about gender equality being the most serious challenge, or violence being the most serious challenge that the world has to face. And when it's in another forum, he talks about racism. I think the importance of connecting these two separate threats, linking it in an intersectional way and linking it to issues of democracy is important, rather than siloing off in different fora, speaking about gender and then speaking about race. So that's my yes but answer.
I can't agree with you more. I think intersectionality of gender and race is critical. And I think most of these statements are knee-jerk reactions rather than looking at the systemic issues. But let's address connections now between race and democracy. Anthony, I want to bring you in here. What are your thoughts on this question about whether we can consider a country that undermines the rights of a group of its citizens on the basis of their race a true democracy? Can you maybe unpack the specific connections between race and democracy in the United States?
Can you be a democracy given the fact that you've undermined the rights of a group or citizens for centuries? And I view this issue at the ACLU, where I'm privileged to direct the organization. I think of democracy as a process rather than an end result, or kind of a journey rather than a destination. And it would be hard to say that the issues of democracy and race are not completely intertwined in the American experience. It is our original sin was chattel slavery. And I don't know if in any secular approach that we have to democracy, we will ever completely expiate the effects of that sin. We must try harder. And, in addition to the original sin of chattel slavery, it was also in the foundational documents where we counted the Black slaves for purposes of political enumeration in Congress and in the Senate. And we counted them as 3/5 human for the count of in Congress, but denied them all any right that you would grant to a citizen. So it's filled with contradictions. And our country, my country, is still filled with incredible contradictions of some of the greatest aspirations and some of the greatest kind of hopes and dreams, and yet a reality which is systemic, as Nicolette said. It is not just a couple of bad actors or a couple of bad apples or a little bit of ignorant prejudice that creeps into people's psyche. There is that, but it's much more than that. It's really about the systemic barriers that impede a person from being able to enjoy the full rights of citizenship. And so we won't complete this democratic experiment until everyone has their full rights. No one is free until we are all free. And so I think we are in the process of perfecting American democracy. And for those of us who work on race, we are working on democracy, right? We are working on our democratic norms, our democratic institutions, our democratic commitments to these set of issues. And I think after the 4 years of the Trump administration, it's been increasingly clear that we've had kind of leaders at the highest levels of our government, including our president, who've espoused racist and white supremacist viewpoints. We had a president who talked about Nazis and white supremacists in Charlottesville as nice people. They were good people on both sides, he said. I've never met a nice white supremacist or a nice Nazi, but our president at the time thought so. And when you have someone at the highest levels of our government who is in charge of policies and institutions and procedures, espousing those viewpoints, it shows you that it's more than just a couple of bad apples or a couple of bad impulses. It is systemic. And so we're in the process of trying to build out from and build back from that very kind of troubling and dark moment, which continues. And I think that's precisely why you saw this enormous kind of outcry that took to the streets in the aftermath of the murder of George Floyd and Ahmaud Arbery and Breonna Taylor and so many others, that finally the American people across races, across generations, small little towns like the one I'm currently in right now, to big cities like New York City, where I normally am, the people just took to the streets to say, this has got to stop. This has got to end. And so I think the questions of race and democracy are one and the same. And yeah. I think we're in the process of trying to perfect it and making a more perfect union, as the founding fathers would say here in the U.S. But I don't know, Nicolette, maybe is any of this off base, or I don't know how you see it. I can always count on you to keep me accountable.
I think for me as a South African, it's a bit scary that you talk about the US being on a journey, because our democracy is relatively young. So I wanna, it actually scares me. I think we passed our honeymoon stage. So I want to ask Nicolette the same question. How is the failure to deal with race in South Africa impacted on the strength of South African democracy? And perhaps you can start by saying whether you agree with me that South Africa has failed to deal with race, given that South Africa is often held up as an example of multicultural success, the so-called rainbow nation. What are your thoughts on that?
Thank you. And Anthony, I definitely agree with you on that journey. I think it's a long journey, and our transition to democracy was always going to be partial, messy, and a long journey, and it's still unfinished. I think that it's also naive for us to think that the political change in 1994 was just going to give birth to a brand new society after 3 centuries of white minority rule. And I think we have to go back to colonialism, apartheid, democracy. It's 3 centuries that we're dealing with, and that's deep-rooted problems. And I think the political system shifted fundamentally in 1994 in terms of the rights and the constitutional democracy. But I don't think we shifted the economy, and I don't think we shifted society's cultures and norms that have embedded white supremacy within it. So we see the old white supremacist order still stubbornly persisting in the new order. And we're still seeing the levels of inequality at that economic level in our country. And this issue of rainbowism, I think that is the biggest failure of 1994. I think us embracing this mythical rainbow nation where black and white were going to hug each other and sing Kumbaya, and we were all going to be at peace with ourselves and the rest of the world. I think a lot of us bought into that notion of rainbowism, and that was a betrayal. It was a missed opportunity for real transformation and real justice and real reconciliation. And we almost just took on this concept like corporate multiculturalism, We accepted certain forms of cultural difference, but we wouldn't accept any of those rights if it was going to challenge entrenched economic power or if it was going to upset notions of equality, substantive equality. And so I think 1994, that moment, the media locally and globally, the narrative was this Rainbow Nation, Mandela the Reconciliator, this feel-good sentiment of the country, and it was quite performative and superficial. And we didn't do the deeper work around racial reconciliation. We put a thin bandage of Rainbow Nation reconciliation over deep, deep wounds, 3 centuries of wounds. And it's still there beneath the surface. And that's what bubbles up every now and then to bite us. I think this failure to address racism in the structure of our economy and in society more broadly led to us prematurely celebrating the new South Africa, as we called it at the time, and the Rainbow Nation. And I think decades after political freedom, many South Africans are still looking for that elusive pot of gold at the end of the rainbow and are still searching for economic justice. And so I think the process is messy and it continues to be messy. But I also think that we're not on the brink of failure. And many in the West speak about South Africa as, this notion of the failed state when we talk about countries that have come out of centuries of colonial rule or apartheid. I think that we have regular, free and fair elections. We have our independent judiciary. We have a robust civil society that's not impeded in any way. We have an independent media, all of which remain intact. So we've built the institutions of democracy post-94. And there are still significant challenges with those institutions, but they do exist. And I think the economic fallout has not been dealt with. And the racism beneath the surface and the unwillingness of us to call out. And, we've also dealt with racism in terms of we'll criminalize individuals who behave badly and it's a bad individual. But the rest of the country at a structural level, we're the Rainbow Nation, we're all hugging each other. And so when we see uprisings happening, we're all shocked, like what happened to the country.
Absolutely, Nicolette. I think it was sort of glossing over what the systemic issues are and addressing how we negotiated from an apartheid government to democracy in the hope that we would eventually get the Holy Grail and not just civil and political rights, but also realizing socioeconomic rights, which I think a lot of people thought it would come naturally. But the second struggle, has just begun. So one of the striking similarities between South Africa and the US is how the law has been, was used as a tool of oppression and discrimination. Then in post-apartheid South Africa and at different times in the United States, lawyers and civil society tried to use the law as a tool for social change, equality, and justice. Nicolette, where are we now? How much has changed?
I think we saw the birth of our public interest law field during apartheid. And I think it's a field that learned a lot from the United States and drew a lot. I think the exchange in the late 70s between the LRC and ACLU and NAACP gave birth to public interest lawyering in this country. And it was in the context of a repressive regime. And by the 80s, I think there was consensus that, sometimes the only way to improve the law is to break it. And sometimes you can tinker at the edges of administrative law reform. And I think the public interest lawyers at that time did an amazing job of tinkering and trying to bring about change through using the system. But there was also a realization that we were going to need a revolution and a constitutional democracy. And so at that time, you had a public interest law sector that was doing legal acrobatics around apartheid laws, but bringing about real relief for Black communities and activists that were being charged under the Suppression of Communism Act or under apartheid laws. But I think the sector at that time was largely driven by white men that were one step removed from communities on the ground, which is very different today. The politics of who brought cases on behalf of whom and who spoke on behalf of whom looked very different in terms of race and gender. Today, I think we have a very different context. We have a very rich public interest law field that continues to act for the most marginalized in society. And I think we've continued to take on those difficult cases, the cases around housing or land or asylum seekers, bringing cases for people on the margins of society and pushing the boundaries of the law and developing the law in a much better constitutional environment. I think when Arthur Chaskelson and Jeff Budlander and Bezos were bringing cases, it was a very different time. But I think what we're seeing is the significant change now is in terms of movement lawyering, where you're seeing the public interest lawyer is not only this great legal mind, but is also an advocate outside the courtroom and is led by communities. The lawyer isn't leading the case. We had the pre-94 period was lawyers led the cases and were the intellectual powerhouse behind the case. Now you're seeing a lot more where a deliberate grappling with how we shift the power between lawyers and their clients and activists and communities. And we're seeing strengthened and more effective outcomes from court cases because they link to popular campaigns that happen outside the courtroom. And so I think what we've learned is that the alliances between the lawyers and the non-lawyers and the communities is critical inside and outside the courtroom. I've been excited by the public interest law sector in terms of race, gender, class, sexual orientation has been phenomenal in terms of the transformation of the staff and the leadership of the sector as a whole. I think LRC has gone through similar changes. And I think that matters. Who brings major class action suits on behalf of whom? There's race politics involved there. And the lawyers bringing the cases today are not doing so in terms of an intellectual pursuit. It's personal, it's political, it's based on lived experience of a younger Black generation of women and queer lawyers, where it's quite transformative in terms of how they're taking up issues. I also think that historically we saw a failure of the sector to really bring cases. In the early days, post-94, there was a failure of the sector to really deal with race. It was almost like we've done race. Apartheid laws are gone. Most of our cases developing the law of affirmative action, and you'll be interested to know this, were being brought by white men challenging the right, challenging affirmative action, like in the US. But the public interest law sector was like, we're not going there, we've got other work to do. And we saw significant invisibility of the issues at the intersection of race and gender. And I've been very excited by the case that the LRC brought this year. I mean, you've got the case of Agnes Sitoli, where the LRC has brought a case to challenge the laws of a specific class of elderly Black married women on the grounds of race, gender, and age, and really looking at a generation of Black women that were born and raised under apartheid, and actually really grappling with this case is really illustrating the persistence of patriarchy, the vulnerability of women in customary marriages, but also addressing the shortcomings of our post-apartheid period and legislation that we've subsequently enacted to protect women, where LRC has been grappling with whether or not we are in fact protecting women, and who have we forgotten about in terms of invisible groups. And so I congratulate the LRC for taking on more and more of those kinds of cases, and I think it's a lot being driven by what the accountability that the public interest law sector sees to communities and to society more broadly. They're no longer just pursuing intellectually interesting cases, but pursuing cases that are actually what matters to ordinary South Africans. And I think that's exciting that we see now.
Nicolette, I think that's, it touches on the point of the way that the LRC has sort of adapted and moved, becoming agile, to look at really the systemic issues you raised earlier around oppressive systems of apartheid that still remain. And one of them is to look at customary law, and it's to look at other issues that really entrench inequalities and structural inequalities and discrimination, various forms of discrimination, whether it's sexual orientation and gender. Because I think that we we also realize that we sort of putting band-aids on socioeconomic problems rather than looking at what are the structural, systemic laws of oppression that still exist in South Africa that needs to be challenged. I want to bring Anthony in and maybe get his opinion on the same question that I've asked Nicolette. What do you think? I mean, in the ACLU and the LRC have had a very similar model of public interest litigation. Do you think that we have made changes? What has changed, and where are we now as public interest lawyers?
Well, I want to pick up where Nicolette left off because I want to make sure we give the LRC due credit, because I think the LRC's work in marrying a concern around systemic racism and economic opportunity, I think has really been at the forefront of the public interest field across the globe. And I think that some of the work that you've done historically in terms of land tenure and housing and some of the kind of the economic issues affecting low-wage workers, I think really, and that's been work that the LRC has really championed for many years, has really been at the forefront now of kind of think a global effort to look precisely at that nexus between the economic and the economic oppression and the racism that's endemic in the U.S. For instance, in our systemic equality agenda, which is our kind of big push in the post George Floyd moment, we said, what are we going to demand that's different? We can't just keep advocating the same old policies that we've always advocated for and pretend it's going to give us a different outcome. If this is a moment of racial reckoning and of doubling down, then we've got to think more expansively, more aggressively, more encompassingly about how to make a difference in the lives of ordinary people. The shooting of young Black men and Black women by cops is a manifestation of much bigger problems around the lack of economic opportunity, the lack of life opportunities. And so we took a page out of the LRC playbook and said, let's think big and let's think broader. Let's not think only about police accountability or employment discrimination. And so our systemic equality agenda at the ACLU is really a very full agenda, asking at the highest levels of government, from the federal government to the state and local government, to invest differently in race and opportunity. So, for instance, one of the things that we have begun to advocate for is a kind of forgiveness of student loan debt, that for individuals who graduate from higher education, either vocational schools or colleges or universities, that has a disparate impact on Black and Brown communities. And so when the ACLU talked about student loan debt as a civil rights issue, people were saying, what? And we then showed them the data that this is a civil rights issue and it is a racial justice issue. We've been advocating, for instance, one of my favorite programs is, we know that one of the things that afflicts our communities, and especially in the low income and Black and Brown communities, is the lack of financial institutions or financial investments. That many of these Black and Brown communities are financial deserts, if you will. And because of the history of redlining, and the banks are not there, and so the banks are not there and they're not loaning in those communities. So we have come up with an advocacy plan to convert some of the post offices into financial institutions. There are post offices in each and every single community in the US. They are brick and mortar institutions. And they are chartered by Congress to be quasi-financial institutions. When I was a young boy, 50 some odd years ago, my very first US savings bond I bought at a post office. So we're talking about the post offices as banking institutions. We talk about postal banking. So instead of Black and brown communities having to go to same-day, payday check cashing institutions that charge usurious rates, let's turn the post office into a financial institution where you can do basic transactions, cashing checks, sending money wires, things that cost our communities a lot of money. And so we've been thinking very expansively. It's been sometimes a bit controversial, but people keep saying, what's the civil rights issue around postal banking? And there's a great scholar who wrote this book that really kind of informed me around the color of money, to think about the racism that's systemic in our banking institutions. And it's a scholar, Ms. Mesra, who I think has done an amazing job laying it all out for us. So I think we're taking a page out of the LRC playbook in terms of thinking more expansively. At the same time, I think the law is an essential tool. And I'm not one of those who says, oh, the human rights movement's become too lawyer-centric. That might be an accurate criticism. But I still think that law is an essential tool. It's not a goal in and of itself. But if you want to fight power, you need the power of good litigation, and you need to use the levers of institutions like the courts to make a difference. There is nothing romantic about fighting for the dispossessed and the disenfranchised and being small and weak. I don't like a fable of where we are the David and we lose the battle, right? David has to beat Goliath for it to be the story I wanted to come out with. And sometimes the way you beat Goliath is by being bigger, stronger, more powerful. And, you know, in going back to the Trump administration, the 4 years that we fought President Trump, we ended up having to bring 434 lawsuits against the Trump administration in those 4 years. Right? If you're going to fight the power of the U.S. federal government, over 100 of them in the context of immigration alone, because our government was waging an all-out war on immigrants and people it perceived to be the other because of xenophobic, nativistic tendencies at the highest levels of our government. So I believe that public interest lawyering is still critical. It is a tool. It is not an end of itself. And I think also Nicolette had it exactly right, where she talked about the importance of having lawyers who will bring different types of lawyering, that they will work alongside of communities. They won't parachute in and out only. That if you want to make systemic change, you have to think about hearing the concerns and having the relationships with these local communities, and then bringing lawsuits that put them in the driver's seat as clients would be in commercial litigation. The clients call the shots. So in public interest, good public interest litigation, the clients in the impacted communities also have to call the shots and tell us where they wanted us to focus, what to prioritize, what are some of the narratives that need to be changed. But I think that you know, if you want to fight the power of entrenched oppression, you have to use powerful institutions. And I think public interest litigation is a key tool for us in that regard. And, you know, the final thing I'll say is I think litigation also helps in a public debate, right? Because number one, it helps focus public attention on an injustice that might seem a bit arcane. And so it kind of helps, you know, put a spotlight on something that's occurring. At the same time, I think it also helps preserve a status quo, especially when we're fighting kind of a government that's trying to repeal rights or abridge rights. It's a way to kind of stop the clock and preserve the status quo. And I think ultimately it's a way for us to kind of map out a longer term strategy. So it's not just only about what happens in court, but the best work we do is when you think about legislation and advocacy and public education all connected to litigation, what we call integrated advocacy, because that creates the crescendo moment for real change and more systemic change.
Yeah. I think, yeah, that's excellent. It's very interesting. I think what Nicolette was called it was movement lawyering, which I think encompasses what integrated litigation would look like and mean. Some people call it activist lawyering, which is also very powerful. And what you spoke about giving agency to communities that we represent, and making them part of that litigation strategy. Following on that theme, Kenneth Brown, in his writing about the use of law by black and white anti-apartheid lawyers, suggested the struggle to extract justice from apartheid courts taught those involved in the struggle the value of the rule of law. Would you agree with that?
I would. I mean, I think it. I think many of the movement lawyers learned as we went, and the best of us, I'd like to think, are self-reflective and self-critical as we go. And it's wonderful to read some of the early writings of people like Thurgood Marshall and others here in the U.S. who had a belief that some of these initial lawsuits would kind of unlock the promised land and we'd all walk into it. And then over time, they kind of begin to kind of understand that there's a door behind a door behind a door behind a door that requires us to continue unlocking all of that before we fully get there. But and I think part of our success now is because our opponents have begun to emulate our own strategies. And so part of what we're fighting in the U.S. are kind of other organizations that have, taken the page out of Thurgood Marshall and taken the page out of the NAACP Legal Defense Fund and the Lawyers Committee for Civil Rights Under Law and the ACLU and others, and have begun to try to fashion a kind of agendas and cases to roll back rights using our very same playbook. And we're seeing that play out in a number of instances that we can talk a little bit more about in the rest of the program. But I think it's important for us to kind of to stand our ground, if you will. These are hard fought for wins, and I think we will continue to kind of to need to wage these battles in the courts. But we need to do so with the involvement of local communities. We need to think through with a bit of humility that the law will not change everything. And so that's why the kind of changing hearts and minds is equally important in changing the legislative process. I think in one of the greatest breakthrough moments in this country has been the recent kind of advancement of LGBT rights. And I think in some ways, the courts caught up with where public opinion was. Public opinion moved further on LGBT rights and equality because of narrative work, because of ways in which individuals influence the thoughts and feelings of their family members. And I think finally the courts, Obergefell was our litigation before the Supreme Court, where they finally allowed for same-sex couples to marry. I think it was less a breakthrough at the legal level and finally about the courts catching up with where the rest of most of the American public was. And I think that underscores the need to lay the groundwork for this type of important work that maybe it's not the ACLU and maybe it's not the LRC, but maybe it certainly should be part of our partners and our sister organizations who lay the groundwork, because it takes a whole ecosystem to have that type of influence. And I think to the extent in which kind of anti-apartheid lawyers or racial justice lawyers have learned to be a bit more humble about the fact that you won't fix these systemic problems with just the filing of a magic complaint in federal court, but that it takes kind of these kind of multi-pronged approaches and a much more kind of involved long-term view of really making a difference. I think a little bit of humility is probably doing us some good. So I don't know, Nick. I don't know. What do you think, Nicolette? Do you have? What are your thoughts?
I agree with what you've said about the importance of the law, but the law not being everything. And I think our tendency to think that the law is going to change society, because I think progressive judgments, even progressive judgments, in our context, we had very early on, we brought our LGBT equality case, which was significant and important progressive judgment, but didn't necessarily result in a change in attitudes at community level. And so our rates of hate crime and rape of lesbian women and homophobia and transphobia still exists in this country, because for us, we first went to court before building the popular campaign outside, which you can compare with the treatment action campaign case, where you had the treatment action campaign mobilizing on the streets and the Constitutional Court ruling. And so I think this notion that you're going to file the magic brief and you're going to change society, I think what happens in the Constitutional Court, Kate O'Regan said in one of her judgments, what happens in the Constitutional Court is very important, but it's not determinative of social reality. And it's not necessarily going to change underlying patterns and power structures. And so you need that. It's one tool, but you need all the other tools. And you need institutions of democracy, not only the courts that are going to bring about justice in a country. I think a lot of the lack of progress on the part of, when the courts have failed to implement, or we don't see it filtering down to community level, it's been laid at the feet of public interest lawyers, the blame. But I think we need to be reframing that the public interest lawyers are just one avenue. We also need the political will. We need the other institutions that expand and support and uphold what happens in the courts. And so you need the lawyers and the non-lawyers to bring about this change. And so when the change doesn't happen, it's not always the fault. It wasn't wrong to bring the case. You needed to bring the case, but you also need all the other mechanisms in place to ensure that the real change happens in the real lives of people on the ground post the judgment.
Yes, I think both of you make valid points. And I think it's really looking at public interest litigation as just one of many complementary tools in social justice work. And, with the advent of social media and using social media campaigns, changing public policy doesn't begin and end at the courts any longer. So it brings me to my next set of questions around our courts. And I think, Nicolette, you touched on this a little bit. Do you think that I'll start with you, Nicolette, both in the US and South Africa, there's an over-reliance on the courts? In South Africa, do you think it's unreal that we're placing unrealistic expectations of the Supreme Court and the Constitutional Court due to the large volume of cases that come before these courts?
Yes, I think that both in the USA and South Africa, we've placed very high, I think it's unrealistic expectations in terms of thinking it's going to deliver on the promise of democracy. The judiciary is one arm. It's one of the institutions that you can rely on. And so I think what we've seen, what concerns me in the South African context, is we're seeing political disputes within the context of Parliament going to court every time, where you can't resolve things through political process. The judicialization of politics has become fraught, and it started to impact on our judicial appointments process as well, in terms of how we're looking at that. I also think that in South Africa, a lot of in the early days, the public interest lawyers thought that just bringing the case, when I worked as a public interest lawyer, I used to tick the box, like great judgment in the Supreme Court of Appeal. And we quickly realized that we needed to do more after that. And that sometimes, and I think the US is a very useful example for us, sometimes your courts are not as progressive as they were 10 years ago. The makeup of the court looks very different, and you need to be quite strategic about whether this is something you want to take. Like in the US, do you want to get to the Supreme Court on this case, or do you rather want to do advocacy on the streets and push for change at the legislative level? And I think that kind of nuance, we were like our post-94 moment of all these amazing constitutional judges and judges in all the courts was a time for us where we could just bring the cases and develop the law. Whereas as you get more mature and as your bench changes, you have to seriously weigh up the risks involved and the unintended consequences for communities where a case is going to get decided based on what the court looks like. So I think our courts make different decisions at different moments based on the political and social context in the country, and becoming more savvy around that in terms of our courts. I think we could be looking at the US in terms of what they're grappling with right now. So maybe Anthony should talk a bit more about this. But I think I've seen it's almost like our judicial appointments process. It's like we've taken a page out of the playbook from the US when I look at the interviews at the Judicial Services Commission. Yeah. It's starting to look like where the ANC and the EFF, the kinds of questions that are being asked in that process have become politically fraught. Have you ruled against us or for us? Are you with us or against us? And it's become very politicized in a way that I think is a bit dangerous in terms of how that judicial appointment process. But I don't think we're in the zero-sum game like the US in terms of judicial appointment. I do think we have sufficient checks and balances and public engagement in our judicial appointment process. But I think there's some worrying trends in what we're seeing at the JSE level that I think we need to guard against. But I'd love to hear Anthony more on that.
It's a good time for Anthony. Anthony, what do you think? What's your opinion on the appointment of judges? What do you think about the role of the courts and appointment of judges in the US?
Yeah, we're living through this very fraught moment, as Nicolette mentioned, in the US. We have, the judiciary is increasingly, after 4 years of Donald Trump, which I can't let go of the legacy of Donald Trump. Even though I live in a different America, it's the legacy of Donald Trump is still with us. He's appointed the largest number of any federal judges of any U.S. president in his 4 years, including 3 U.S. Supreme Court justices. So we're living with the implications of a much more political judiciary, and individuals who are hostile usually to questions around rights and liberty, and who are ideological in their opposition to much of our agenda. At the same time, I think we have to work harder as advocates. Like Nicolette said, we have to be very strategic about which cases we bring. Not every great injustice should make its way to the Supreme Court. We'll have to make up our minds about which ones we're able to bring, the right set of facts, the right set of circumstances, the right theories. In the U.S., how the case comes up through the court is very important through different jurisdictions. So we try to be very strategic about the venues in which we will raise certain cases. And then as advocates, we have to convince judges who don't start out with us. We did everything right? We filed our family separation lawsuit. This was a lawsuit challenging Trump policies that separated parents from their children in deportation proceedings, what we called torture, what Physicians for Human Rights call torture. So we decided to bring this case in California. Usually it's a progressive jurisdiction. And we filed in federal court, and we drew a Republican appointed judge, Judge Sabral. And we're like, okay, try as we might, we drew a conservative judge in a kind of liberal jurisdiction. And then over time, we just built the trial record where we got him to rule for us, and ultimately was the one who said that the Trump administration had to stop separating parents from their children in deportation proceedings, and then ruled that all the parents who had been separated had to be reunited with their kids. So I think that's the test of good advocacy, is like, how do you bring the cases with the right set of facts and the right set of theories, where you don't only convince the people who start out agreeing with you, but you bring people who may not always agree with you. And I think that's where we're going to earn, our public interest pay, is when we decide and we find ways and theories and facts and circumstances to bring those types of cases. And so, yes, it's become increasingly challenging. And yes, we have to be strategic. And yes, not every case should be filed or brought. But no, I'm not willing to say that all is lost. And I think there are certain kind of ways we can bring these cases. And I still think good public interest litigation can can succeed, even given some of the most challenging of circumstances and some of the most skeptical of jurists. But it is an issue, it is a problem. And certainly we see that in the context of women's rights, which I know we want to cover a bit. So maybe I can kind of add to that after if we want to move to that issue.
Yes, I mean, it definitely, when you questioning the compositions of courts, representations of women and communities of color is important to level the playing field, and it does question the legitimacy and independence of the courts when you're loaded with very conservative judges with conservative views. But I want to bring in Nicolette. Nicolette, you were one of the first lawyers at the Women's Legal Center. They played a critical role in advancing women's ability to fully participate in public life as a key aspect of any democratic society. Women's participation is inextricably connected to their ability to control their reproductive lives. And we know that it is most often women of color who bear the brunt of the efforts to undermine reproductive rights. We're also seeing significant backsliding on the rights of women globally. So I want to maybe ask you to talk about the rollback of rights for South African women in particular.
Thank you. I don't think we're seeing the kind of rollback or attack on our constitutionally entrenched rights in South Africa. I don't think we're in the same position as women in the United States may feel after the last week in terms of the Supreme Court challenges to Roe versus Wade. I think the issue we have is we do have some of the most progressive laws in place in the country, particularly when it comes to sexual and reproductive rights. And I think we were quite strategic. And it's something that we could have gone to the Constitutional Court to develop the right to bodily autonomy as enshrined in the Constitution. We went to court a lot of the time to develop the right to be free from all forms of violence, the equality rights. And with bodily autonomy, the fight was we want national legislation on the choice on termination of pregnancy and entrench the right to abortion in national legislation that gives effect to the Constitution in very clear, unequivocal terms around abortion on demand. Because with such a contentious issue globally, the whim of the court and the ability of a court to overturn a decision versus clear national legislation put in place to interpret the right, I think we did the right thing in not, and we then dealt with Christian lawyers bringing all the constitutional challenges to the Choice on Termination of Pregnancy Act. But I think when I see what's happening in the US, I think the reliance on the court to continuously, since the 70s, develop the right, post Roe versus Wade, develop reproductive, the right to bodily autonomy and reproductive rights for women through the courts and through the judges interpreting the right to privacy, as opposed to getting some other forms of protection for women. Has probably been a missed opportunity, but it's easy for me to say sitting from outside of the US context. But I feel like that was a good move on the part of South Africa. If I look at the views in South Africa at the moment, and if this went to a public referendum, just like the death penalty, South Africans would want the death penalty and they would not want abortion on demand probably. And so I think there's certain issues where that was important. I do think South Africa, I've been quite impressed globally. We're seeing the anti-gender rhetoric and conservative agendas on the rise, particularly on issues of sexual and reproductive rights. And you've seen this alliance of countries that are pushing back, and where countries were previously quiet, they're now more vocal around not giving rights to women, to bodily autonomy in particular. And you see the religious, the fundamentalist Christians and Islamic countries coming together in global spaces, really pushing back. So what happens in the US could influence what happens in the rest of the world, where you're seeing authoritarian regimes being much more willing to shut down and close space for bodily autonomy. I was very impressed with South Africa. We pushed the South African government a lot, but in the ICPD plus 25 conference held in Kenya, where lots of countries there was the fear of backsliding on issues of reproductive autonomy and not wanting to speak out in favor of the right to abortion. And we had the South African government actually being outspoken around a woman's right to choose and what's entrenched in our constitution, and speaking around the Africa regional context. And so when I was sitting in that meeting, I thought, we're quite hard on South Africa in terms of implementation of our rights, but actually in global spaces, our framework for the protection of women's rights exists and is there. I think the fact that women, our high rates of gender-based violence, our high rates of femicide in the world points to the deep change that we need to do in terms of shifting patriarchal attitudes in the country. And the problem isn't the law. We have very progressive laws on gender-based violence. We have very progressive laws on termination of pregnancy, protecting LGBT rights. I think we're sitting with a different challenge. And I think we need to think about that in terms of how we make it more real in the lives of women on the ground, because women aren't feeling that sense of equality that they deserve. But I don't think we should, when I look around me, I often say to the South African feminist movement, we have a government that has the political will to do the right thing and is not spewing rhetoric that's against protecting women from gender-based violence or femicide, that's not trying to roll back on rights in terms of the Choice on Termination of Pregnancy Act, whereas we are seeing a rise of authoritarian regimes that are rolling back and shutting down gender studies at universities in other parts of the world. And so I always say, let's keep it in context. There are times when we can be quite proud of what our government is doing in global spaces and not aligning with the anti-gender movement.
Then maybe let me bring in Anthony, because a lot of people may not be aware about what's happening around the Texas law. I think a lot of people working in the space probably has a rough idea. What is the threat to Roe versus Wade? And your little, the enemy number one, is this sort of inherent to this judiciary or the Supreme Court that is now deciding on the matter? What we talked about earlier, they are judges appointed by the Trump administration.
Yeah.
Maybe explain to us, what is the threat against Roe versus Wade and what is the Texas law?
So I think Nicolette had it right. I think we're going to have to take a page out of the South African experience and try to find a way to codify some of these protections around women's reproductive rights into statutes, because I think that the common law basis for these rights is increasingly under sustained assault in the U.S. So, in the U.S., it's been a 40-year plus battle since 1973 with Roe versus Wade that established a woman's right to terminate a pregnancy, pre-viability, and it saw it as an essential part of a woman being able to decide her future, her autonomy, her agency, that if you cannot control the most basic decisions over reproduction, that you were going to be a second-class citizen de facto. And when we won that case in 1973, the opposition's been working single-mindedly for almost 38, 39 years since then to undo it. And they are now on the precipice of accomplishing their 39-year goal of reversing Roe versus Wade. And there are three cases before the U.S. Supreme Court, Sherylle, as you mentioned. The Texas case that allows third parties to sue abortion providers. A Kentucky case that the ACLU argued that would allow the Kentucky Attorney General to jump in and repeal abortion protections in that state. And then the blockbuster case, the Mississippi Dobbs case that was just argued in the early part of December. And by every reading of the arguments, it looks like we will likely lose the protections of Roe versus Wade. There appear to be 5, as many as 6 Supreme Court justices that will repeal that Supreme Court decision that guaranteed a woman's right to decide when and if she would have a child. And that would essentially open up kind of a race to the bottom at the states, that different states will have different rules and regulations. New York will be progressive, Mississippi will be regressive, California will be protective, Georgia, let's see, and so it devolves this battle to the state level, which is, spectacularly problematic. The idea that a fundamental human right about being able to decide when and if you have a child should not be open for the states to decide. That there is the United States of America with some constitutional rights guaranteed to all people and not just New Yorkers or Californians. But that's where we are. And so we're going to need to codify it, like Nicolette said. We're going to have to bring kind of efforts legislatively. There'll be political efforts. There'll be no place to hide. These Republicans who say, oh, I'm pro-choice, but I don't know if I like Roe versus Wade, or they're going to have to make up their mind now because they're going to be on the line. And, we now hear some of these kind of like half-hearted kind of defenders of reproductive rights now have a little bit of buyer's remorse because they said, oh my God, is this really going to happen in America? Susan Collins is a U.S. senator who voted in Brett Kavanaugh on the Supreme Court. And she told us that he guaranteed her he would uphold Roe versus Wade as established jurisdiction, as established jurisprudence. So she was assured that he would uphold that law. And now she's on the court. He doesn't need Susan Collins, and maybe he's changed his mind. So Susan Collins has got, a little bit of a conundrum. She's now going to have to get behind legislation that codifies Roe versus Wade in the Senate. There'll be no place to hide. These politicians who want to play both sides of the fence, at some level, it makes it very clear, right? The dust settles, and then you're going to have to make up your mind. Where are you, right? And ultimately, we'll hold them accountable. That's what the American people will have to do. The overwhelming majority of the American people think a woman should decide when and if she has a child, not a politician. So now we've got to make sure that the body politic gets there again. But it's political work that's ahead of us. And it's long-term work. It's the same type of long-term work that we've got to do on racial justice, on reproductive rights, on reparations. It just requires us being like water on stone, assiduous and unrelenting. And we need to think different strategies and different tactics given the moment.
So we've run out of time. It's been such a rich conversation, but in many ways a depressing one, in that we're certainly not seeing the kind of progress we need to end racism. And in fact, we are seeing a regression. But I want to end on a hopeful note and ask each of you, in the work that you are doing, what do you see that helps you keep the faith and remain optimistic? I'll maybe start with you, Nicolette.
Oh, it's hard to be optimistic, but I think what gives me hope is, I think the work of the ACLUs and the LRCs of the world, the continued work of public interest lawyers, human rights activists. I think no matter how depressing things get, we continuously rise up and fight the challenges. And I think we'll overcome this as well. There's a saying, we shall overcome. I think this is that moment in time. And I think we've been talking a lot about what's been happening around reproductive rights in the US. I'm hopeful if you think about what the green wave movements have done in Latin America, what happened in Argentina. We've had a progressive judgment of the Inter-American Commission. We've seen what's happened in Argentina, where women have just taken to the streets and said, you are not going to do this. And I think that mass mobilization and popular campaigns, we saw it with the Me Too movement and the ripple effects of the Me Too movement around the world. We saw it with the killing of George Floyd and the global solidarity that we saw around the world, with people rising up saying this is an issue that we're going to mobilize around in terms of racism So you're seeing movements make those transnational connections, which I think is an exciting space that we lost in the last period as governments have retreated into nationalist agendas. Civil society needs to push towards transnational solidarity, alliance building across borders. And I think the time is now between the US, South Africa, between the North and the South, between movements for racial justice and gender movements. The pressure needs to happen across borders. And I'm excited because we're seeing that happen and we're seeing that solidarity come about. And I'm an old woman now. I was working in this space 25 years ago. I love the younger generation that are fiery and that are challenging us all and to think differently around how we pursue social justice. And it's hard work and it's difficult sitting through being questioned in that way, but I think it's making us a more mature sector, and I'm excited about that. And the sector's grappling with its own issues internally. The sector now more than ever has been willing to say it's not only about the state or the corporate sector and non-state actors, it's also about what happens within our own spaces as social justice institutions. That kind of the raw truth-telling that's happening and debate that's happening around what kind of future do we want to imagine for ourselves, that does make me excited about the future. And I'm not going to be there fighting it all the time, but I'm excited by what I see. And I'm excited to see the resilience of institutions that have been around for decades. It's not about creating new institutions always. It's about how institutions transform themselves. Yeah. And I love what I've seen in LRC. So it's been so great for me to be part of this conversation because seeing LRC's trajectory over many years is just so powerful. And of course, being with you, Anthony, is amazing because I've read so much about the ACLU's work over many decades. And so it's been wonderful to share experiences with you.
Oh, great.
Thank you so much, Nicolette. Anthony?
I would just echo what Nicolette said. I mean, I think first, what keeps me optimistic is the fact that this is a long marathon, and institutions like the LRC and the NAACP Legal Defense Fund and the ACLU, we're marathon runners. You know, we've trained for this, and our institutions are seed beds of new leadership. And I'm an older man than Nicolette is, than she is an old woman. So if she's an old woman, then I'm an ancient man. But I have watched successive generations of wonderful lawyers come out of the LRC and then populate leadership in government and other NGOs, at foundations. And I'm just thrilled to watch the leadership of groups like the LRC, the ACLU, our alumni, our best assets. They serve in government, they serve in other NGOs. So I think our biggest enemies are not the conservatives or the Christian anti-rights groups. Our biggest enemies are fatalism and cynicism. And if we allow them to creep into our communities, in our organizations, into our hearts and souls, then we will lose. And if we can fight cynicism and fatalism, and the idea that we can look at the progress we've made, and yes, there are setbacks, and yes, there are strong headwinds, and yes, we might have to pick ourselves up and dust ourselves off. But these youngins, as I call them, like Nicolette was saying, are fantastic. They're so much more sophisticated than I was 40 years ago when I was starting out, right? It's just like they're asking really hard questions of society, of their own institutions, of their own leaders. Great. You know, we should build that muscle. We should build that kind of that sinew that binds us all together. And so you cannot be cynical or fatalistic in the light of what we have to accomplish. And I think it's a wonderful journey to be on. And it may take us a little longer, it may take a lot more work, but failure can't be an option. Not when we know what we're fighting for and that we know we're right. So to you, Sherylle, to you, Nicolette, you inspire me to do this good work, and then we'll go back and get to work, right, my friend?
On that note, I want to say that I'm a big fan of both you, Anthony, and Nicolette. And you may say that you're older, but I'm sure that you are wiser than all of us put together. And so I want to thank you for sharing your wisdom with us. And I want to thank everyone for watching this. Goodbye.